Morning, may it please the court and counsel. This is a situation I've had the privilege of representing William Charles Jones, referred to in all the record as Charlie Jones. This was clearly, we believe, a business dispute, a civil business dispute that was made out to be a criminal theft because of a dispute between the parties that were involved. What clearly was lacking from the evidence and the sufficiency of the evidence was that this was a construction project, and the victim, Wayne Greiner and John Wayne Construction, claims that these monies were supposed to come through his company. Even if they had come through his company, the materials would have still been paid for. There are notations on the checks that state that they were for doors, they were for a permit, they were for supplies. Yet my client was found guilty of all of these funds and taking all of these funds when there were expenses and materials paid for. The evidence was insufficient in that there was no accounting provided by John Wayne Construction or Wayne Greiner that showed that they paid for any of these things. The direct evidence
But
was...
wasn't the
Pardon?
owner of the property to pay the contractor, and then that person was to pay your client? Your client wasn't supposed to get the money directly from the customer, correct?
That was in dispute. The Halls, Andrew Hall, clearly testified that he wanted to pay the contractor, the subcontractors direct himself, as he was basically managing the job himself and had chosen my client to manage it for him, as they had prior been in a construction project together that didn't involve John Wayne Construction. There is no contract that we're following here. There was simply a proposal of cost. There's nothing that said that the cost of, and that Mr. Hall was to pay John Wayne Construction. That is what Mr. Greiner claimed afterwards, but clearly there were fees that were paid out to other subcontractors. If you look at the alleged proposal, this was over $120,000, and this is only a small part of the job. So there's many other subcontractors and people that were paid directly other than my client for the reimbursements and the USBCI.
What about the $850.17 where you have a charge and you have a reimbursement, but you don't have it going back to the person who was charged to? So that's $850. Isn't that a jury question on that issue?
Well, there was never any evidence presented that Mr. Greiner paid that. Furthermore, as in some of the other construction...
Well, I'm not sure I understand that. What do you mean there's no evidence that Mr. Greiner paid it? What is it?
There was a Home Depot
Right.
receipt,
Okay.
but there was never any payment for that receipt on that credit card.
Well, grand
presented.
theft is to take a property of another. You don't even necessarily have to prove who it is, and all you have to show is that it's not your property, and it could be just a temporary deprivation. So once again, why isn't that $850 at least enough to prove third-degree felony grand theft?
Well, this was a situation where there was an ongoing construction project. And as was explained through the other construction projects, they would get to the end to determine and do an accounting. My client, and the emails that were not allowed to be presented in, said that there was continuing discussions and who owed what. There was never any...
But your position isn't that you have the right to self-help. If you are owed money for one project, doesn't mean that you have the right to take money on the other project to make things even. That wouldn't be your argument.
No, I'm
would it?
talking about within the same project.
Within the same project.
Within the same project, there were costs and things that my client was getting paid for by the Halls. The payments between Wayne Greiner and my client were never reconciled or accounted for because Wayne Greiner cut the project short, cut my client out of it, didn't allow him to finish to be able to say, okay, on this particular Hall case, you owe me this and I owe you this, and that's what they did on their other
You
projects.
used a credit card to pay for things at I guess it was Home Depot, and then the client reimbursed for the same $850 and didn't tender that. I understand what you're saying, but if you're looking at that in its as one transaction, it's hard to see how, why didn't he just forward the $850 check over? He may be owed up money at the end of accounting. That is where perhaps one goes from civil to criminal.
It's still, I believe, that there's nothing to show that the credit card account or payment was ever due or paid by John Wayne Construction. And there's nothing to show that my client wasn't going to go ahead and do that. They cut off all communication.
So you're saying that for one to use that credit card as account, it has to be paid by the owner of the credit card. Is that your position?
Well, there's nothing to show that John Wayne Construction is out any money on that credit card. Furthermore, it was the Halls.
You are saying that. I just want to make sure I understand you. You're
Yes.
saying that that the state had to prove that the victim was out the money, that merely charging it was not enough on that card. You have to prove that the victim actually paid the $850 at the end of the month. Is that what you're saying? I'm just trying to understand.
Right, I understand. What I'm saying is there's no proof that John Wayne Construction was ever out that $850. There was money sent to John Wayne Construction with no accounting. John Wayne Construction admitted that he received $15,000 something on this project, but he never said exactly what that money was for. Where he got those funds, he never showed the checks that he received from the Halls for that amount. We don't know what he received, what was for what supplies or what materials. It just happened that that one check was the same amount as the Home Depot, and it was for the doors.
Do you think it's just a coincidence?
No, I don't think it's just a coincidence. I think it's a lack of accounting and mismanagement on both sides of my client and John Wayne Construction, that there was no accounting done of the construction job. John Wayne Construction received $15,000.
But the jury didn't accept that defense.
Maybe the jury did not accept that defense. But at the same time, we believe that the judgment of acquittal should have been granted because the evidence was insufficient that there was even a loss. On the other checks, there were for the permit fee, clearly John Wayne Construction said he never got the permit on this job. But clearly the job started and inspections were being done and the job was completed. So that's something that my client paid for that he was reimbursed for. There were doors, there were window changes, there were other things in those checks. There was a management fee, and all of those things my client paid for and he was reimbursed. Mr. Hall testified that he didn't write any checks out for something that he didn't see a receipt for, materials, supplies, and different items like that. So as far as all of the checks, the only one that has a receipt of any kind or any evidence from John Wayne Construction is that one $850 check from Home Depot, which would then go to my other argument. If it wasn't a judgment of acquittal, then the only amount that would be for grand theft would be way under the $20,000 amount. It would be a much lower amount. But then again, I mean, how much money did John Wayne Construction receive? They never showed what they received and what it was for, whether it was for reimbursements, whether it was for other items, whether it was for the management fee, or what those items were for.
I don't understand the big picture of what the defense was in this case. Am I understanding correctly? The defense in this case was, look, we had this ongoing relationship of how money went back and forth between us, and I thought I was owed money that I wasn't getting, and so I just went ahead with the custom and usage of how I got paid, and I took money that I thought belonged to me. Is that basically the defense in this case?
No, the parties did insurance restoration jobs. They did those all over the country. This was a completely different job and project than any of the others that they had been involved in. This was a home renovation. They weren't doing those things. Mr. Hall contacted my client, Mr. Jones, because they had a prior relationship. It looked like a good deal for Mr. Jones and for Mr. Greiner. Mr. Greiner wasn't going to have to do anything, and at the end he would get a 10% fee. The job got cut short because they were having a dispute over other items and other things that were paid for. So Mr. Greiner got angry and replaced my client with Robert Greco as the manager on the job. Even when he did that, he didn't do a final accounting. He claims he's still owed money by the Halls, but he never billed them, never did an accounting, never finished the accounting of the job. There would have been more money for John Wayne Construction if it had just been billed by John Wayne Construction themselves to the halls. The job was completed, and with the job being completed, the only amount of money that John Wayne Construction, they didn't put out what they paid on the job. There is no evidence of that.
Felt he did nothing wrong. Could you give us the explanation, now sitting post-trial, of what the text was, acknowledging what he did was wrong and apologizing to the contractor?
The parties had had a business relationship of one kind doing the restoration insurance work. They did this project. They were in the process of going into a company that they were forming that was the Vineyard Company, that they were going to do insurance restoration nationwide. That's why my client was getting out of the USBCI Corporation, so there wouldn't be any conflicts between the project that he was going to be doing with his other partners, including Wayne Greiner. He was trying to save his business relationship. He went to a meeting in Orlando where he thought they were finally going to sit down and do the accounting of the hall job and say, do I owe you any money? Do you owe me money? Where are we on the hall job and the other jobs? When he got there, he found out that Wayne Greiner had already been to the sheriff's department, accused him of theft, accused him of things that he did not do. He was also at that time accused of forging a check, which it was later found out that Andrew Hall himself changed the name on the check. He was being accused of all those things at that meeting. He was also being threatened to be thrown off of the balcony. When he was done, he was just basically dumbfounded by the whole meeting itself, thinking, where's my business? Where's my partnership going? And he thought that if he apologized and could try to bring it back around, that he might be able to save the business relationship, and that's what he testified to. It wasn't that he thought he took money or things that he wasn't entitled to. He wanted to try to calm it down. He was afraid, and he was trying to fix his business relationship.
I know you didn't ask for a specific time for rebuttal, but our deputy marshal has just put on the light to say you're about 3 minutes left if you want to start wrapping up or save your time for rebuttal.
Yes. And as far as the restitution, it's the same issue, that these checks went for items that were paid for, clearly, as Mr. Hall testified, and yet the checks for restitution purposes are taken as a whole, along with the 10% markup that would be a business profit, yet Mr. Greiner never billed for that remaining 10% markup. We don't even know what the total amount of the hall job was, as when my client was no longer in charge of the project, the halls continued to pay subcontractors direct through Robert Greco. As Mr. Greiner himself testified, he never received any more checks on the hall job, even though he was managing at the end. So I reserve the rest for rebuttal.
Likewise, please.
May it please the Court, Anisha Worthy on behalf of the appellee, the state of Florida. I wanted to touch on one of the points that opposing counsel made during her argument. She was very emphatic that there was no contract between the victim here, which was JWC, and the halls. And that's simply not true. The defendant was not a general contractor, so he did not enter into a contract with the halls. He procured the contract through his agreement with JWC. The proposal was on JWC letterhead. He represented to the halls, according to Mr. Hall's testimony, that he worked for JWC and that all of the permits and licenses would go through JWC, but he would be spearheading the project. So that was Mr. Hall's testimony about the defendant's representations to him. So when you look at who the contract was with, it was clearly with JWC.
Wasn't he supposed to get paid a monthly fee for doing the work that he didn't get?
The defendant?
Yes.
Yes, there was some testimony, and it was a little unclear. The victim testified that because he was going to be project managing this job, it was in his backyard, it was in Vero Beach, that he would be entitled to a project management fee. However, the victim also was very clear that the JWC paid the defendant for any project management fees, not any clients. And that's another important point to make here, because all of the testimony at trial was that the defendant was never authorized to take any money from clients. The victim testified, for example, that his agreement was with the defendant was for the defendant to get a percentage of the profits at the end of the job. So you had to wait until the job was complete to see what the profits were. The defendant during his testimony confirmed this as well because he said all of the payments went through JWC. There was even a point where he was talking about sometimes JWC needed him to help get money from clients. If the clients sent him a check or if he picked up a check, he forwarded to JWC. So there was no testimony at all, even from the defendant, that he was ever authorized to take money directly from clients. Later on, without any explanation, in light of his earlier testimony that JWC did all the collections, he all of a sudden said, well, I was entitled to collect money from the halls. But he never explained where this agreement or where this authorization came from. So when you're looking at this JOA, you see clear evidence that he misappropriated money. You see clear evidence that he was misrepresenting the misappropriation and tried to conceal it. And you see his admissions. And we would argue in response to opposing counsel's argument that that text message was not merely trying to save an ongoing partnership. That text message has to be read in light of the previous day because the text message came on June 7th, but they had a meeting in Orlando on June 6th. And at that meeting, according to the victim, the defendant, and this is a quote from the victim, admitted to taking money out of that job that he shouldn't have taken. So when that text message came this next day, the quote-unquote wrongdoing was specifically because he took money from the halls that he was not authorized to take. And we would also submit that his very arguments on defense and on appeal show his intent. Because when you look at the trial court, for example, he insisted that this was merely a dispute. And he also said repeatedly that in his mind, JWC owed him money. You even see that statement in the text message he sent. And I'm going to quote from the text message, "I believe in my mind you owed me money." So that explains why he took the money from the halls. Because when you have the evidence that he was only entitled to money at the end of a project, the project was still ongoing, but he thought he was owed money from other projects.
Could you walk me through how you got to the amount over 20,000? Because I'm sort of troubled by
The $28,000?
28, yeah,
Oh, okay.
but statutorily to make it over 20,000.
Okay.
Because by my mind, the only thing that seems, at least facially here, is the 850.17 for the Home Depot. Where else? How do you get to the 28,000?
The $28,000 was because there were 17 checks. And if you look at the statute talks about depriving a person of a right to the property or the benefit of the property. It also talks about appropriating property for his own use or to any other person that's not entitled to the use of the property. So when you look at who was entitled to those 17 checks, JWC should have received all 17 of those checks. 17 out of the 17 checks that were admitted into evidence, the defendant expressly asked the halls to write them either to himself or USBCI. So that's where you get that $28,000, because when you add up all of the checks, I believe it's...
But weren't the checks going to some of the subcontractors?
Some of the...
So, I mean, it wasn't like he was using the money for himself.
We don't know that, actually. And we want to be very clear. The state, as well as the victim, had no way of knowing what those $28,000 checks were. But the statute clearly contemplates...
Why is that so?
Because the checks were supposed to come to JWC. The defendant directed the checks from JWC to himself or USBCI. So the victim had no way of knowing whether the checks were legitimate or otherwise. But the bottom...
Couldn't you have gone to the bank and found out?
The checks were written from the hall, so the victim had no way to go and check someone else's bank account. They were checks that the client wrote. Instead of writing them to JWC, he wrote them directly to the defendant or to USBCI. So the victim had no way to double check to see where the checks went.
How did he know that they went there then? I mean,
Because
if he knew enough to know that the checks went someplace else, it seems to me the state should be able to prove that they went to a place they shouldn't have gone.
Well, you have to recall, the victim did not know this at the time. The project ended in November 2013, and it was not until November 2013 that the victim went to the hall residence and spoke with the Halls, and that's when he discovered that the checks had been written directly to the Halls. So as the project was ongoing, all the defendant knew was that, the victim knew was that he was no longer receiving the checks. All he knew was that all of the outgoing costs stopped. And you also have to recall that the victim was in New York because he was working on a project. It was sometime after Hurricane Sandy. So all of his communications with the defendant was via email or phone calls or text messages. So all the victim had to go off by was what the defendant was telling him. So the defendant procured the job. He emailed him a copy of the proposal, and he got approval to do the job, which is why the defendant went ahead and pulled everything through JWC. And so when the victim was following up with the defendant kept representing to him that, oh, I will get everything taken care of, because once the victim realized that we were no longer getting any more money, all the outgoing costs had stopped, he began asking the victim. We also have an email exchange, for example, that occurred in September 2013. The number one job on that list, and there were several jobs that the victim emailed the defendant about, the number one job was the Hall job. And he said, where are we on the Hall job? There was an email that the defendant wrote back to the victim, and in that email, the defendant represented that JWC would have a check by the end of next week. We knew that that's not true because he wrote back in October, but we know that he started diverting funds from the Halls in April. So when he represented...
Can I stop you just a second? Because I get it. I understand that the state's position and the victim's position was the money was supposed to come to me, and then I was going to pay the other guy back. And that didn't happen. But if those checks actually went to pay for costs in doing the project, how is that theft? I mean, they didn't send the money in the right direction, but if they actually paid for legitimate expenses for the project, that wouldn't have been the victim's money anyhow. That would have gone to the subs that were doing the work.
No, it actually would have been the victim's money because the money was supposed to go to the victim.
And then the victim would have to pay the sub.
Exactly. Well, that's what the statute says, though. The statute says appropriate the property of his own for his own use or to any person who's not entitled. So when you look
But
at...
the sub was entitled. It was just whether it went this way or it went that way.
The sub was not entitled to the money. The subcontract was entitled to get paid, but the way that the subcontractors got paid was through the general contractor. The money went to the general contractor, and then it went to the subcontractors.
I get it.
But we don't have any evidence, though. And we're going to have, the state has to stand firm that we don't have any evidence that the subcontractors were in fact paid. There's none. But when you look at the statute, the state doesn't have to prove where the money went. We just have to prove that he misappropriated for either his own use or somebody who wasn't entitled to it. And he was clear. His testimony confirmed that he wasn't ever entitled to the money. Nowhere in his testimony did he say that he was authorized to take payment. All payments was always supposed to go through JWC.
Let's say hypothetically I owe Judge Levine money, so I've got a stack of cash in my hand. I put it down and I said to Judge May, I've got to pay this money to Judge Levine, but I leave the room and Judge May says, I'm going to take it upon myself to pay Judge Levine. Has she committed a crime?
Yes, she's committed theft because the money... This is in hypothetical world, only in hypothetical world. She has, because the money belongs to you. What you intend to do with it, the fact that you may owe Judge Levine the money does not entitle her to take the money. The money still belongs to you, and that goes to the case that I cited, Thomas. I think that
is a different theory of theft than I've ever heard before.
Well, in Thomas, it talks about, and I'll quote this because I thought that it actually went to the issue. Whereas here the claim is to money owed, and in order to satisfy the claim, the creditor takes money or other property to which he has no title or right of possession, then the intent to steal is present. So the bottom line is he had no title or right to the money that he received.
That's where he converts it to his own use. I mean, in other words, if your evidence had shown that he had taken that and bought things of his personal use, that would show conversion. But what kind of conversion here is he just turns around and pays for the subcontractors, or at least we don't know what he did with it. There's no evidence in front of us. Your theory is purely that if the contract says it goes to A and B does what A should have done, then that's a conversion.
No, that our theory is not that it's converted. We're not saying that he converted to his own use because we have no evidence of that.
Right.
What we're saying is that he took possession of the money, and he had no right or title or possessory interest. His right to that money came at the end of the job, and it was only 30% of the net profit.
Let me ask you a question. Isn't the intent also part of this too? In other words, what evidence do you have? Maybe he thought that he was expediting because this guy was up doing work up in New York, you said. So maybe he thought, well, it'd be a lot easier for me to just do it quickly, and that way the project gets done quicker. I mean, there could be a construct that way. Is that going to be a conversion, even though the intent at the time of taking that check was purely benevolent?
I still wouldn't think it would be a conversion, but it still would be intent to deprive, because the intent goes to whether the money belonged to him. And if he did not have a right or interest in the money, the fact that he was just trying to speed up the process does not negate intent.
So let me use a hypothetical. Somebody sends me a check, and I sign it, and I deposit it, and it says SLEVIN, but I don't notice there was no E. It's actually Judge Levin up in Martin County. So now, did I steal from Judge Levin in Martin County because I didn't notice it? But I converted it.
No, absolutely not, because it would be a good faith. First of all, you're not claiming that you had a right to the money. You're claiming that there was
deposited.
you're claiming that there was a mistake. You had a good faith belief that the money was yours, not that you necessarily had the right to the money. But that's completely different, because here there was no basis for him to believe that he had a right to the money by his own testimony. His own testimony was that the money was supposed to go to JWC.
But you were not able to prove that any of the checks, or were you able to prove that any of the checks written by the homeowner were written directly to the defendant?
Yes. There were 17 checks, and I believe, if I'm correct, 15 of the checks were written directly to the defendant, Charlie Jones, and then 2 of them were USBCI. But all of those 17 checks were written to him to either him or USBCI at his direction. So there was testimony from the halls that Charlie told me to write this check to him. There was testimony from the halls that Charlie told me to write this check to USBCI. We also have a couple of checks that were initially written to JWC, and when Mr. Hall gave them to the defendant said, no, you need to change that and make it to USBCI instead of JWC.
Okay, thank you.
And I did want to briefly, I have about a minute left, to talk about the restitution. And I wanted to make an important point, because the defendant continues to argue that the restitution order was based on adding up the total checks. And the face of the order shows that that is completely not true. The trial court did not add up the $28,000 in checks and award that in restitution. That restitution order included 3 things. It was the 10% profit that was clearly in the contract. It was the approximately $11,000 in shortfall, because the victim testified his company spent about $26,000 but had only received about $15,000, and then it was the project management fees. So this false assertion that
Project management fees, weren't they to go to the defendant? Wasn't he the one managing the project?
Again, because the testimony was that the defendant was paid everything through JWC, the project management fees were supposed to go to JWC, and then JWC was going to remit payment to the defendant at the end of the project. And I believe that's all of my time.
Thank you, Ms. Warren.
Thank you.
Well, first of all, as far as the basis to believe that he was authorized to take the money, there is no basis for my client not to believe he was authorized to be able to reimburse for the expenses when he went to pick up items and he paid for them himself. Then he showed the receipt to the halls, and the halls paid him. These were reimbursements, and they're not like each check is for $500 or $1,000. They're for specific dollar amounts, along with 41 cents, 68 cents. So clearly Mr. Hall had a receipt for something that showed up there at the project when he gave my client the money.
Let me just ask you, because I didn't understand the answers to some questions asked when you were here up last time. So your position was that there wasn't this agreement that everything had to be paid to the victim, and that your client was owed some money, and so to some extent, he had the payments go through him, and he paid for expenses and subcontractors, and then kept some money to himself? Is that?
This is a job that was different than all of the other
I
jobs,
know that.
right?
I know
Okay.
that, but
So he
please
took,
answer the
he
question.
bought things, he took them to the halls, they reimbursed him for it. Or, I mean,
What about the checks that were made, so the checks that were made directly to your client's name were reimbursement for
there were either
items purchased?
reimbursements or there were some that were the project management fee. There's a $3,000 check, which was for 2 months of the project management fee, I believe, and another $1,500 check. Those are the only ones I believe that are whole amounts. The others all have a distinct item as to 68 cents, 41 cents, 2,000, whatever it was that arrived on the job that he paid for on that day. There is nothing in this proposal or anywhere, any written agreement, anything that says that my client cannot manage the money on the job. Where is that? There is nothing. As far as the details on the job, the state had the ability to get all of the hall's banking records and all of the records on the job if they wanted to. They also could have gone to the inspector, the building inspector, and gotten all of those things. They never provided anything that showed that JWC wrote checks out to anyone on these jobs. There's no accounting by JWC Constructions.
I see you're out of time. You want to wrap up, please?
Yes. As far as this job, the halls wanted to manage the job themselves so that there were no liens. There's no liens on this. Mr. Hall testified all the subcontractors were paid. He paid everyone. They're saying they don't know where the money went. They could look at who the subcontractors were. They were all paid. There was no theft on this job at all. There was nothing that was taken by my client from anyone that wasn't due to him from the project management, direct from the halls, or for reimbursement of an expense. There was no final accounting. There is the one $850 check, but there was no final accounting to establish that my client committed any kind of a theft. He was taking care of a construction project. So we
What was
believe
the explanation for the $850 then? What was your client's explanation for that?
the $850 was a cost on the job. He was going to see what that's only one receipt on the Home Depot card. We don't even know where the rest of the bills on that Home Depot card that he had or how those were paid for. That is just one receipt on the Home Depot card. As far as a final accounting, he would have been paying JWC when they sent him the bill and said, here's the credit card bill for this. There was emails, you can see that Cheryl, in the one email that was in, that was as to where they were on the hall job, and Cheryl was the accounting bookkeeper. When she gotten that Home Depot credit card bill, she should have sent to Charlie Jones and said, here, you need to pay this. He'd already gotten the money from the halls and it would have been paid, but that never happened. JWC never managed to bill my client for anything else that was due on the job, or even to bill the halls for anything else that was due. It just kind of shut down. But it was completed. It was completed by JWC Construction, yet they claim they don't know where the money went when they completed the final inspection and completed the job with their own employee, Robert Greco, and not my client, Charlie Jones. So we believe that he didn't convert any money. They could have gotten all of my client's banking records as well to show when he got money from the halls, where did it go? They failed to do that. They failed to prove the case. And we believe that my client this should be reversed and he should have gotten the judgment of acquittal.
Thank you. Have a good day.
Thank you.